Hey. All persons on the hand before the Honorable Justice of the Appeals Court now sit in Boston, Florida, from the Commonwealth of Georgia. Your attendance and shall be heard. I said Commonwealth of Massachusetts, this court is now open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Justice Peter Sachs. To my right is Justice Sabita Singh. Joining us by Zoom is Justice Maureen Walsh. Will be your panel for the two cases this morning. I assume the parties know that the order was changed, so we'll be hearing the Gray case first and the Harvard case, Classic Restaurants case second. If you've been to the Appeals Court, you know they're 15 minutes aside. There's no rebuttal. We've read the briefs. We're familiar with your argument, the record, the facts, so we would encourage you to get right to the core of your argument. And with that, I'll call the first case, 22P1259, Commonwealth versus Claude Gray, and we'll hear from Attorney Renaud.
Thank you, Your Honors. Suzanne Renaud for Claude Gray. Thank you for having the hearing today. I know it's been delayed a couple of times. Just to start with, this case centers on these constitutional rights, on the rights of the Fifth Amendment and the Sixth Amendment, and really what the lower court judge's gatekeeping role is. Because in this case in particular, that judge was really the only person in a position to understand if and how the dangerousness hearing testimony was compromised by the invocation of privilege that the witness had, because it didn't come out prior to her, having a Martin hearing, the basis for her privilege. Now that happens sometimes, as Pixley says, it's probably the preference for that to happen. That didn't happen here. We can make assumptions, obviously, based on what she said at the plea hearing, that it had something to do with the narrative that she provided to the court during the dangerousness hearing testimony. But that just goes to show that there is a potential waiver by testimony that is inherent right there, because she talked about the elements and the facts that underlie the assault and battery, and yet she said something that was incriminating.
Counsel, I think it's interesting that you're starting with the trial judge's crucial role.
Yes.
Wasn't it the trial judge's role to make a finding regarding this waiver, and could the judge have done that without the issue being presented?
Well, Your Honor, when somebody raises a Fifth Amendment privilege, it is a matter of law that it has a two-pronged piece to it. The first is whether or not there's something incriminating, and the second is whether there has been a waiver. Would it be ideal if the parties, either the Commonwealth, who was a proponent of the evidence at that point, or Mr. Gray, had said something about waiver? That would have been ideal. But as a legal issue, the judge should have done it, and it appears that he didn't.
What do you rely on in saying that in every situation, a judge must consider whether there has been a waiver?
Because the legal principles, and I'm sorry I don't have the cases handy there, it's in my reply brief.
I think you rely on Penta.
I do, and I think that what that is, I do, thank you, Your Honor. And what it is saying is that it's not something that's going to come up in every single case. But what we do know here is that she had prior testimony. Now, the other reason why we're not sure, and I should just say that if this is a waiver by testimony issue, and why neither the Commonwealth's attorney or Mr. Gray himself raised it, is because if this is something that had arisen post-testifying, that would have incriminated her, then we wouldn't be having a waiver by testimony discussion. But we don't know. And so the judge was honestly the only person who is in that position. And now, again, you can listen to the Martin hearing. I'm not asking to do that in any way. But it appears that he did not engage in that inquiry. And the reason why I'm supposing that is because after she testified at the plea hearing, he didn't mention anything about how that potentially had raised a waiver by testimony, even when the next day the parties wanted to call her as a witness. So, yes, ideally, the parties would raise this. But if it didn't happen, it's a legal matter, and it also, when we say waiver, obviously we're talking about whether it's going to be evaluated under a substantial risk standard, rather than just saying that it's not an issue, it's not a live issue to be discussing on appellate level at all.
No, but I mean, can we even review it under a substantial risk without findings, right? Without findings from the trial judge?
But I don't believe, well, then you can remand it back to the trial judge, I suppose, but I think that it is fairly clear because you have the evidentiary record here. I mean, in this court, when you have documentary records, you are in an equal position to the judge below to be, he wasn't the person who was there at the dangerousness hearing. You can see how she testified, both at the plea hearing and at the dangerousness hearing. It's there in black and white. And so you certainly could make the same findings that he could make, or the findings that I'm suggesting to you, which is she testified a page, it's in the trial record, pages 90 to 100, and I think again on cross-examination, on page like 123,
So
I think that's the page,
you said
122 to 123, about the facts relating to the assault and battery.
You said you weren't urging us to listen to the tape.
Oh, no, I'm not asking to listen to the tape. I'm sorry, Your Honor. I think that the Commonwealth suggested in her brief that Mr. Gray was asking to have the...
Okay.
Oh,
But do
no.
you think we need to listen to it in order to determine whether, I mean, the judge made a determination that she had a privilege, and then you're saying either it was waived by the 58A testimony or it was waived the next, I guess, late in that same day?
Yes.
By the statement, the sort of victim impact statement. How could we say she didn't have a privilege without knowing what the basis of it was?
I think that, well, I am going on the presumption that she did have something incriminating, Your Honor. I think what she said in open court makes me believe that there was something incriminating there. So I am saying I do not think that that's why I think that that part of it is clear. Whether the judge actually engaged in the waiver analysis is something that I am again presuming he didn't do. I think it would make I think you probably should listen to the Martin hearing to see if he engaged in that part of the legal analysis. Instead of just presuming that he did not, since that is available to you, and it is not available to me. But, you know, I think that there's a second problem here. And, you know, I'm focusing on the judge as the gatekeeper, right? Because when the Commonwealth ends up putting in this testimony, and the Commonwealth has an obligation under Supreme Court law, under ethical rules, to put in testimony that they don't knowingly know is incorrect. And if the Commonwealth or the judge allowing the Commonwealth now knows that this testimony is knowingly incorrect because there is a lie, that is a huge problem about the integrity of the entire trial, about, you know, Mr. Gray's Sixth Amendment rights, about how the jury came to these conclusions, because that was allowed.
Counsel, can I interrupt for a moment? The first issue, would you agree, that we need to address is whether or not the waiver issue was preserved, correct?
Yes, because that would determine the prejudice versus substantial risk.
Or anything. I mean, as Justice Singh has indicated, we don't have, the judge below didn't have an opportunity to address this. And so assuming I get over the hurdle of whether this was properly preserved in an issue that an appellate court could address, I want to make sure I understand your argument. And that is a victim impact statement could somehow be considered testimony, and I'm assuming under oath, which then waives any Fifth Amendment privilege that the victim had prior to asserted. Again, if we address this issue, I just want to make sure I understand once we get over, if we get over the hurdle,
On the first,
whether we can address it.
Thank you, Your Honor. On the first issue that you raised, I would say this, again, to repeat that you do have the documentary evidence that the judge himself would have had in front of you, so you can address it. I also referenced about 4 or 5 cases in my reply brief, albeit they were mostly footnotes, and it was dicta, where the appellate court was able to make an assessment about the waiver issue, notwithstanding the fact that it wasn't raised in the court below. So I don't think that that is precluding you from moving forward on this. As far as a victim impact statement is concerned, I think it depends, honestly, about what is said in the victim impact statement. The judge specifically asked for the witness's statement about disposition. That's what the statute asks for. This witness went well beyond that in the way that she was describing it. So yes, when we're dealing with testimony by waiver, it's not testimony that we consider, for 803 purposes. It's not something that has to have confrontation clause principles underlying it. It could be an affidavit. It could be just about anything. It has to do with how the facts emerge in a particular case. And so it very well could be that any witness's impact statement, when they go into the facts and when they start talking under oath, as this woman did, it wasn't just a, sometimes...
Is she under oath?
She was under oath. She was put under oath because sometimes there's a piece of paper.
There's no cross-examination, so this isn't recorded testimony that would be admissible.
It's not recorded testimony.
You're just looking at it for waiver.
Just for waiver purposes, yes. This is not something that could automatically come in the way that the 58A hearing testimony came in. So, and because they're different, but they both have an impact on this testimony by waiver
But
analysis.
After the witness testified at the victim impact, in her victim impact statement, the proposed plea was rejected, it went forward to trial. At that point, the victim was not, nobody proposed to call the victim.
Yes, they did. The next day at trial, before the trial started, both parties talked about whether or not it was proper for her to sit in the courtroom, and both parties said, I would like to be able to call her if I can.
If I can. No one really said, I want to call her.
Well, Mr. Gray said, I'd like to call her, and the judge said,
If I can.
You cannot. And so I think that...
The judge sent the witness out because the judge didn't ultimately make a determination about whether she could be called.
Your Honor,
if the judge said she can't be called, then there was no need to sequester her.
I think he did it in an abundance of caution. I read the record differently than you did. I read the record as both the judge and the Commonwealth basically conceding that it was not proper to call her. And both parties had expressed an interest previously to calling her. And so I would say that that exchange where Mr. Gray very explicitly said, I'd like to call her as part of my case, and the judge basically dismissed that, whether or not he then sent her out and sequestered her or not, the long and the short of the order that he gave, the judicial order, was you cannot call her, it's not permitted.
Is it essential to your argument that he wanted to call her but was prohibited from doing so?
I don't think so, because the original motion in limine had already been decided. And I also really am going to put this back on the judge. The only difference that makes, Your Honor, would be whether or not the error was preserved or not. I think that it still goes back to the judge and the judge's role in protecting the sanctity of the trial, and the judge's role in making sure that when a prior recorded testimony is coming in, that the witness truly has the right to be unavailable. And I do not believe that in this case that the witness would have been determined that way if the waiver argument had been explored. But I think there's a second part of this, if I may, which is when we're dealing with the Sixth Amendment intersection with the Fifth Amendment, the prior recorded testimony also has to have a meaningful opportunity to cross-examination. And my second argument, I really focus this on if the basis for the Fifth arose after the fact, because there really wouldn't be a meaningful opportunity to cross. But I would say also, I think this is kind of important as well, that there is a presumption of regularity when there's cross-examination that the witness is telling the truth. So if they truly don't remember, if they truly don't know, if they truly don't have a sense of what happened, that's what they're testifying to. When a witness says, presumably in the Martin hearing, based on what she said at the plea hearing, when the witness says, I started it, I lied, I committed perjury when I did that, which is essentially what she did.
We don't know what she's referring to when she said she started it.
That's correct, Your Honor. But, for all intents and purposes, when somebody says that, she was asked directly on cross-examination, and it's in the trial record on page 122 to 123, tell us what happened. And she said, I don't remember. And so now she's coming back. and saying, I remember. So I would say there's also not a true, even though the question was asked, and even though that was cross-examination by an attorney, I would say that it could be seen as not truly a meaningful opportunity to cross if the witness is purposefully lying to the tribunal.
So your brief recognizes that, at least implicitly, that this would be breaking new ground in Massachusetts. Are there any cases from other jurisdictions about this issue?
I would have to get back to you. I don't know. I'm going to assume that there might not be. I would just hesitate about the waiver by testimony breaking new ground, Your Honor. I think that that's well established in Massachusetts. There's a
No, right.
okay.
Waiver by testimony, yes, but whether there was a fair opportunity to cross-examine earlier based on some fact that is disclosed later.
Yes,
or
Your
some
Honor.
testimony. That's the.
That would be the new piece,
Well,
and I
if
think.
there's authority elsewhere, it would be helpful.
Okay, I will look for that and see if I can find anything, Your Honor, and I will get back to you. Now, obviously, there's a third issue here. I would just rest on my brief on that point. If there are no further questions, thank you very much.
All right, thank you. And we will hear from ADA Sweeney next.
Good morning. May it please the court, Elizabeth Sweeney on behalf of the Commonwealth. For the first time in the record, the defendant alleges that the dangerousness hearing transcript should not have been admitted due to waiver by testimony, and also that the victim committed a waiver by testimony. The victim was found to have a fifth, as this court is aware, after a Martin hearing, and at no point during the entire record in the entire trial was it ever addressed that the victim waived her fifth. There are two issues here. First is the admission of the dangerousness hearing transcript, and second is waiver by testimony relating to the 258 victim impact statement that she provided as her right as a victim. The concern in Taylor that is addressed with waiver by testimony, that the testimony would allow the victim to remain in a witness-selected posture did not happen here. The dangerousness hearing transcript was admitted pursuant to pro incluso after hearing. The victim was provided a Martin hearing.
I'm sorry to interrupt. Could you just slow down a little bit, because due to the Zoom, the words are getting a little scrambled, so just 10%.
I'll try my best, thank you. Again, the concern in Taylor that the court would permit the testimony to remain in a witness-selected posture did not happen here. The parties disagree on whether or not the defendant and the Commonwealth attempted to call the witness, and I would direct this court to volume 4, page 38, where the judge said she could... Does that matter?
What does it affect other than perhaps the standard of review? I mean, we'll review for substantial risk regardless, right?
I think that
it's preserved?
Yes, sorry, there's a delay. I think that it does affect the standard of review, substantial risk of miscarriage of justice, but also it shows that in conjunction with the entire record, the defendant called a witness. He, in fact, himself testified. He had standby counsel, and he was aware that when the witness's name was read to the jury and she was sequestered, he could have called her as a witness. The judge said on page 438, volume 4, page 38, I'm not ruling one way or another. If there's any possibility she could be called, she's out. And
you're saying that he had to call her and have her take the fifth in front of the jury, or what is the purpose of calling her?
I'm saying that the judge is not required to sua sponte find a waiver by testimony. The defendant could have called her and could have argued waiver by testimony, and nowhere in this record.
How does that go to anything other than the standard of review?
I think that the standard of review is incredibly important with this set of facts, with a substantial risk of a miscarriage of justice, where he heard her victim impact statement and he was aware that she had a Martin hearing, and prior to the Martin hearing, the parties were asked to provide input under Pixley, and the defendant said on volume 3, page 15, that the issue is not ripe as to what she will say on the stand and her willingness to testify. It's not a concern at his time. So at every stage of this case where there was an issue with the defendant possibly arguing waiver by testimony, he essentially committed forgo and did not raise that issue before the court. And I think that we are looking at this issue in the sense that it has essentially been created by the record. There are no cases that I was able to find in Massachusetts or in other jurisdictions that state that a judge is required to, after a fifth or after a victim impact statement, say she committed waiver by testimony and bring this to
So again, that seems to go to the standard of review. But
Yes.
So let's talk about the merits. Do you agree that the statement or the testimony at the 58A hearing was a waiver by testimony, subject to whatever might have come up in the Martin hearing, which none of us know at the moment? But if it weren't for that Martin hearing, would you agree that the 58A testimony was a waiver by testimony of whatever fifth she had before that?
I would agree that the victim made statements regarding the substance of the fifth. I agree that they are somewhat vague, and she did address, allegedly, on this big record, what she provided to the court for the Martin hearing.
So that sounds like you're saying, yes, it was waiver by testimony.
It could be interpreted that way. However, the requirement that the judge says you committed waiver by testimony, you no longer have a fifth, inappropriately interferes with the role of the judge, the role of counsel, and the role of the pro se defendant.
I'm not suggesting, I don't know that anyone's saying the judge was obligated to sua sponte raise this. We're just trying to take this piece by piece and understand if this 58A testimony was waiver by testimony. It sounds like you're saying it was. Not saying the judge did anything wrong necessarily, but at least can we agree on that much?
I can agree on that. I will turn the court's attention to Commonwealth v. Borans, where they said that grand jury proceedings are separate, and I would argue that in the same vein, possibly the victim impact statement, where she's providing her statement under her right under 258A, can be analyzed under the same view. She's
not compelled to provide that, and even if she were, she's not compelled to get into the underlying facts. So would you agree that what she said in particular at this hearing could be a waiver by testimony?
Could be. However, she
was it?
I think that's an excellent question. And her statement, where she did go into the facts and into her fifth, was somewhat of a waiver by testimony. However, she was exercising her right under 258B, so I'm hesitant to say that a victim's impact statement automatically in any circumstances creates a waiver by testimony.
Sure, but you would agree that she has a statutory right to make that statement, but that isn't likely to supersede the constitutional right of the defendant. I
agree, yes,
okay.
Yes. And
counsel, just so I understand, you're in agreement that in particular circumstances, a victim impact statement could constitute a waiver, correct?
In particular circumstances, yes. However, the statement that was provided here, where she did address allegedly the substance of her fifth, and it is a vague statement, I think the parties can agree on that, did not put the court in a situation where it was permitted to say, I'm going to revisit the fifth, or I'm going to go back to address the Martin issue. And if you look at the context of when she made that in the plea and then the trial, the defendant was aware that he could have called her or could have questioned that or could have brought that in. And I think that again goes back to substantial risk of a miscarriage of justice.
Okay, so just so that I understand, in general, when a victim asserts a Fifth Amendment privilege, right, and then later decides to waive that privilege, in whatever circumstances, a colloquy needs to occur. Yes. In order to make sure that the victim, or let's just say the witness testifying who is now waiving the Fifth Amendment privilege and providing testimony that may incriminate he or she, it's done with knowledge, right? So that blurting out something in court without some sort of warning and advice occurs. So I'm not really sure how this fits in when a victim stands up and the court tells the victim that they have a right to give testimony about the impact of the crime and sentencing, how this equates to waiver of a Fifth Amendment privilege without any protections for that person.
So I agree, and as I argue in my brief, that the victim, we're arguing that it was not voluntary. She was provided an opportunity to speak. She did have an attorney for the Fifth. It's unclear if that attorney was with her during that victim impact statement. As I mentioned with Justice Sachs, I can see how one would view this as a potential waiver. However, the record is devoid of any information that she was told as the limits of her victim impact statement and any sort of protections that were provided as compared to her testimony in the dangerousness hearing. And we did argue that it was not voluntary in our brief regarding the 258A statement versus the dangerousness hearing transcript. And I think that the juxtaposition of both of those statements shed light on what is voluntary and what is not.
Are you suggesting that the defendant could have called a witness at trial to testify to what the complainant said at the victim impact statement?
I'm suggesting that the defendant heard what the victim impact statement was and what she said, and he had the opportunity, was never barred from calling her. He could have addressed this in numerous ways.
Well, I'm asking specifically, could he have gotten the fact that she made that statement into evidence through anyone other than her on the stand? I mean, wouldn't it be hearsay?
It would be hearsay. I would expect that the judge would not permit that to occur. However, it was recorded on FTR. It was recorded in the courtroom. She was sworn. So how does that make a difference to whether it can come into evidence? Because I thought your brief suggested, well, he could have gotten her statement at the her victim impact statement into evidence to cast further doubt on her credibility before the jury if he'd wanted to. And I'm not sure I understand how he could have gotten that statement into evidence. I think that the defendant could have argued that he was present in the courtroom and she was sworn under oath, but I don't know why she was sworn under oath as a victim, providing an impact statement. I've never seen that before, and attempted to introduce it, but again, that did not occur.
Are you suggesting as a prior inconsistent statement?
It would be inconsistent with her dangerousness hearing transcript, yes. And he was aware that, again, he called a witness, he himself testified, and he's pro se, and he chose to not exercise any of these options before him, including arguing waiver by testimony. So again, I know I keep directing the court back to the substantial risk of miscarriage of justice, but the record is just not here to address this issue. In the cases cited in the defendant's brief, in the reply brief, Penta, King, Voisin, and Leclerc, and all of those cases, a witness was called and was on the stand, and the judge inappropriately interfered with the questioning of the witness under the Fifth Amendment issue, but that did not occur in this case. So I just don't think that the record supports the issue of addressing waiver by testimony based on that he did not call her, the Commonwealth did not call her, and the judge never said you cannot call her.
Is there such a thing as a subsequent inconsistent statement exception to the hearsay rule?
Not that I'm aware of, other than what we just previously addressed, that the victim made the inconsistent statement at the impact statement versus the dangerousness hearing transcript. I think that would be the only exception under the hearsay rule that I could think of at this moment that would fit. But again, he did not raise that issue, and we're looking at it under a substantial risk of miscarriage of justice standard. And her statement was not voluntary.
Do you think we need to get to listen to the recording of the Martin hearing?
I think that it could assist the court in reviewing the substance of the Fifth. I think that with this issue and the issues raised in the defendant's brief, the court would be permitted to do that. However, reviewing the judge's finding of the Fifth Again, that's something that the court would, I believe, view for where it's his finding abuse of discretion. And looking at that after the fact, where again, I keep turning the court back to substantial risk, there wasn't a challenge, and the defendant, prior to the victim being subject to the Martin hearing, said that as to what she's going to say, I'm on page volume 3, page 15, it's not an issue with his concern at this point, and essentially waived that challenge. And
Yep, seeing no further questions. Thank you for your argument.
Thank you.
All right. Thank you both. Let me just find out if we need to take a break to deal with any technical issues or whether we can go. Okay. All right, our second case will be number 23P372, Classic Restaurant Concepts versus President and Fellows of Harvard College. Okay, and it's Mr. Brown?
It is.
Right. Good morning.
Good morning, Your Honors. May it please the Court, my name is Phil Brown, and with me is Amelia Gray. We are here on behalf of Appellant Classic Restaurant Concepts, LLC. Before I begin, I'd just like to thank the Court for the accommodation and the scheduling, and just would like to note the professionalism and diligence of your scheduling clerk, Catherine Irizarry, in helping to make this possible.
Thank you.
We appreciate that.
Thank you.
As you know, in our brief, we focus very much on the fact that there are material facts at issue, inferences that need to be drawn in favor of Classic. There are findings of credibility that need to be made in this case. Witnesses have to be examined. But if there's one thing that I could ask the Court to take away from this oral argument, it's that Harvard breached the covenant of good faith and fair dealing and the covenant of quiet enjoyment when it caused Holyoke Street to be closed and used for staging. Now, why do I say that? As you know, the covenant of good faith and fair dealing requires the parties to not do things that are going to take away from the fruits of the contract. So, what are the fruits of the contract in this particular case? From Harvard's perspective, it wanted to have a tenant at 8 Holyoke Street who would be paying rent and who would be operating a particular type of restaurant, a restaurant, as they say in the lease, of distinction. The prior restaurant you may be familiar with was a restaurant named Sandrine's, which was a well-known French restaurant in Cambridge. That's the restaurant that they wanted in there, and they needed a tenant who was going to be able to pay rent. From Classic's point of view, the fruit of the contract was the ability to put in a restaurant from which they would be able to make money. This wasn't a case where Classic was looking for a guarantee of a profit. What they were looking for was the ability to not have Harvard, essentially, as I said in our brief, throw marbles under their feet in terms of being able to make a profit. As we put forward as evidence in both terms of testimony from Mr. Goodwin, who was one of the principals of Classic, as well as from our expert, Christopher Muller, Dr. Muller, who was the former dean of the BU Hospitality and Administration School. You have to have, in order to open up a restaurant, you need access, you need visibility. As Mr. Goodwin testified, it needs to be welcoming, it needs to be a place that's inviting. And that's particularly true when you're asking your tenant to operate a restaurant of distinction. By closing the street and using it as a staging area, Harvard effectively precluded or made much more difficult the ability to operate a restaurant like that. And it's our contention, but of course this would be something for a fact finder to ultimately decide, it's our contention that those closures, that the dirt, the grime, the noise led to the closing of the restaurant. We understand that Harvard has a different view as to why the restaurant ultimately closed, but we believe it's for a fact finder to make that determination ultimately.
I actually had questions about your fraud claims.
Certainly.
I think I understand for my part at least, understand the covenant claims. But on the fraud and fraudulent concealment, what is the earliest you contend that any of the Harvard real estate people you were dealing with knew that any significant closures of Holyoke Street were certain or even more likely than not or reasonably probable? And when was that, and was it before the First Amendment to the lease was signed?
Well, first of all, whether or not the Harvard real estate people knew or not, we think we're suing Harvard. We're not suing individual persons within real estate. But
Right.
I understand your question.
When should they have known so that what you characterize as their partial disclosure became misleading?
They should certainly have known by the point where they were selling the space to Classic.
Well, but what evidence do you have that they knew? I mean, I don't see any statement in your brief that they knew at the time in December 2014 when there was the email exchange between one of the, I forget if it was Ritter or Hill, and one of the Classic people. So when after that? The earliest I saw was October 2015 when Consigli had the closure scenarios.
Well, there is evidence that Mr. O'Brien, who was part of Harvard Real Estate, was attending meetings back in the summer of 2015 at which street closings were part of the discussion.
Where's that evidence?
That would be in the meeting minutes, which are they're in volume 8. I believe it's page 80, but I'm not sure on the exact page. We put in a series of weekly meeting minutes where certainly Dunster Street closings are discussed.
I saw the reference to Dunster Street. I didn't see Holyoke Street, which is the basis of your claim.
That's
The
correct, Your
earliest
Honor.
mention of Holyoke Street closings I saw was in October 15.
And that's correct, Your Honor.
Okay, so that's that's after the First Amendment to the lease, so that can't have been an inducement.
Well, Your Honor, we believe that, again, we're talking about Harvard itself. We're talking about Harvard had knowledge from the, we believe that
Well,
the inference that can be drawn is that Harvard would not have put together and accepted the gift of from the Smith family if it knew it was not going to be able to do what was necessary to do what was necessary to do the construction or do the renovation.
Didn't the Consigli 30B6 deponent say it's faster if the street is closed?
He absolutely
If
did.
can't close the street, makes it more difficult. So the mere fact that they were doing the project didn't require, at least on this record, that the street be closed. So the question is when Harvard either knew that or, of course, Harvard is arguing that this was a prediction about the future. When did it become sufficiently likely, if not definite, that the street would close? And I'm not seeing anything before October 2015 that even talks about it.
Well, you're certainly seeing that in October 2015, there are extensive plans that have already been put together.
After the First Amendment. So we're focusing here on the fraud and fraudulent inducement claim.
Correct. And those plans took time to develop. Whether or not those plans were in process in the summer, we have Mr. Tess, who was hired to do...
You don't have evidence that they were, discovery closed, you don't have evidence that they were being developed in the summer and that someone at Harvard knew or should have known about them?
Well, we have evidence, we certainly have evidence, and I would still rely, Your Honor, I understand about the Dunster Street, Dunster Street piece, but we certainly have other things that were put into the record showing that there were meeting minutes that were not included in the summary judgment record, which may be able to be included in the trial record if we go to trial, from the entire summer at which street closures were discussed. What you're asking, Your Honor, is really when does it become material? When does it become cohate as to when it's required to be able to disclose street closures? And I would say, Your Honor, that it was known from the very beginning that streets were going to be closed. Whether it's going to be Dunster Street, Holyoke Street, Mass Ave, streets were going to be closed. And that was not conveyed to our client either before they signed the First Amendment lease, but let's also think about between the signing of the First Amendment lease in September and when they were actually able to begin construction took several months because the bankruptcy hadn't been fully completed. So there was a period of time where the lease had been signed at least by my client. It had not been signed yet by Harvard. I get that when they signed it in December, it relates back to the date of September. But there was a actual period of time where nothing was going on with respect to 8 Holyoke Street, but at the same time, there were being plans developed, certainly as Justice Sachs has alluded to, in October, where Holyoke Street was going to be, was considered to be a topic for closure.
So I think your argument was that if you'd known that at that time, perhaps the build-out plans could have been changed somehow.
Absolutely.
The judge said there was no evidence of that in the record. And, of course, you were obligated, as you've recognized, to operate a destination restaurant of distinction, and it can't be a fast food restaurant, and so forth. So what do we do with that if there's no evidence that it could have been scaled back? I gather the point is you could have done a less expensive, even if you were obligated to pay the rent, you could have done a less expensive build-out and incurred fewer expenses, maybe gotten through the tough period while the street was still closed and so forth. But what's the evidence?
Well, the evidence certainly is in our interrogatory responses. Interrogatory response number 26, where we talk about, we would have done things differently. There's evidence from Mr. Goodwin who testified that they would have done things differently. What they would have done, we don't know because they were never given the opportunity to decide what to do. But certainly it's an inference that can be drawn in favor of Classic and that should be drawn in favor of Classic, that as sophisticated restaurateurs, they would have taken steps to protect their investment. One could even, when you look at the amount of money that they actually lost by doing the type of renovations that they did, it frankly would have been cheaper for them just to pay the rent. They would have lost less money had they just paid rent and never opened, as opposed to what they did.
Didn't there need to be some evidence of that cited in opposition to Harvard's summary judgment motion?
Well, I believe that we did cite evidence to that in the terms of Mr. Goodwin's testimony. We cite that in our brief, and we also cite it in terms of our responses to interrogatories, as we also, I believe, referenced in our brief.
Where is the citation to his testimony on that issue?
I can give it to you. I don't have it.
In your brief.
It's
then.
in our brief, Your Honor.
We'll just search for the name Goodwin, and
I will.
That'll narrow it down.
There you go.
All right.
22, I think there's 22 references. But in any event, that is key to, it's certainly key to what we might be able to do if we had given the chance. And there's not, you can't prove a counterfactual. That's certainly an issue here. We weren't given the opportunity to try to do that. Harvard certainly knew by January that roads were going to be closed, and that was information that was never conveyed to us. Your Honor, I see that my time is about up.
I got another minute and 18 seconds. Maybe you can address the 93A claim. If, hypothetically, we were to revive one of the claims like the good faith and fair dealing or quiet enjoyment, does that automatically revive the 93A, or is there more that we would have to decide about that?
I think that should automatically revive the 93A. As you know, 93A is a sui generis claim. I think it would be up for a fact finder to make the decision as to whether an act is unfair or deceptive, and then at a later point, the judge would make a decision as to whether that unfair or deceptive act rose to the level of a 93A violation. But I think it's certainly enough, if there was a breach of the covenant of good faith and fair dealing, should be enough to allow the 93A claim to at least go forward for a finding of whether the acts in total are unfair or deceptive.
All right. Seeing no further questions, thank you for your argument.
Thank you, Your Honor.
Mr. Riley.
May it please the Court. Thank you, Your Honor. My name is Richard Riley. I represent President and Fellows of Harvard College in this case. The very first thing I want to do is to acknowledge the extraordinary contributions to Harvard's summary judgment motion and the appeal brief that were done by Attorney Catherine Garrison, who truly carried the ball in both of those respects and is on maternity leave now, was not able to be here, wishes that she could, but I did want to acknowledge that right up front. I think that the Court has indicated correctly that the focus of this case is on the fraud claims. I will get to, if there is time, the rather clear legal bases why the implied covenant of good faith and fair dealing, quiet enjoyment, negligent misrepresentation. I think that the law is clear that the summary judgment was correctly entered on those grounds.
My questions, I'm only one member of the panel, my questions were more about the covenant claims for Harvard.
I will turn right to that then, Your Honor.
So where the lease requires Classic to continuously operate a restaurant, why doesn't the covenant of good faith and fair dealing prohibit Harvard from unreasonably interfering with Classic's ability to operate such a restaurant? Whether you did or not is maybe a question of fact, but why wouldn't?
Well, the covenant of good faith and fair dealing, Your Honor, is a covenant that the promises that are made in the contract will be honored and will be performed. That brings us back to the question.
But it's an implied covenant.
The implied covenant is the covenant that the promises made in the contract will be faithfully performed.
It's that you won't do anything that will prevent the promises in the contract from being performed.
Correct.
So if Harvard caused Holyoke Street to be closed in a way that unreasonably interfered with CRC's ability to operate a restaurant, why wouldn't that breach the covenant?
Well, if Harvard committed an act that unduly interfered, there's a lot baked into that question, much of which there was no record support to indicate. Harvard did not close Holyoke Street. Consigli Construction closed Holyoke Street.
Well, Harvard caused the construction to occur and hired Consigli to do it and knew certainly at some point that it was going to be closed, and Consigli said it doesn't have to be done that way, it makes it faster. So let's assume for purposes of argument that Harvard caused Holyoke Street to be closed. Could that constitute a breach of the covenant?
Not in this case, Your Honor. I don't believe, because the covenant of good faith and fair dealing, where it talks about it's serious interference with the right of a party to reap the fruits of its contract. It's not a guarantee. In this case, it wasn't the closure of Holyoke Street. Number one, it wasn't closed completely. There's no evidence that it was closed completely.
I mean, it sounds like we're getting into questions of fact. Was there a serious interference?
Well, there also was no agreement going into the contract and no knowledge that there would be any closings of Holyoke Street, and therefore...
Perhaps not before the contract, but once the lease is signed and the construction begins, isn't there an implicit agreement not to do anything that interferes unreasonably, substantially, significantly with Classic's ability to perform its obligations under the contract?
Well, there's an agreement. The agreement is modified by what the parties knew and expected. That has to be a part of what the denial of rights are.
And Classic knew there was going to be a substantial construction project. What they didn't know, it appears, is that Holyoke Street was going to be closed for substantial periods, because as you've very capably pointed out in your brief, and Ms. Garrison as well, perhaps nobody knew it in late 2014 or mid-2015. But once the lease is signed, construction gets underway.
Once construction begins and construction is underway, then I do not agree that a normal construction procedure, whether it be pile driving across the street, whether it be a partial or intermittent closure of the street, I do not agree that any of that amounted to, for purposes of the summary judgment decision in this case, amounted to a serious interference with the ability of Classic restaurants to obtain the fruits of what it legitimately expected by entering into this contract with Harvard in September of 2015. It expected that it was going to be opening a restaurant across the street from a 2.5-year-long substantial construction project that it, Classic Restaurants, had 9 months from December of 2014 until September of 2015 to explore what the ramifications of that were, which they did by going to one of 9 public hearings. There were 9 public hearings. Classic Restaurants went to one of them, but it was a substantial one.
Well, you haven't pointed to any others at which the street closures were announced.
The street closures were not announced in the Cambridge Historic Commission public hearing. What was announced...
They might not even have been known or thought to be very likely until October of 2015, after the lease was signed.
That may very well be true, Your Honor. So still, if there is a construction project of the magnitude that was illustrated at that hearing and in the other hearings that Classic Restaurants could have gone to, or the permits that they could have found if they had looked that were being issued in connection with the project, the normal process of a construction project of that magnitude, having that occur, where you've told them that it's going to occur, you didn't tell them the streets were going to be closed, you didn't tell them you were going to do pile driving, you didn't say that there was going to be, whatever other kinds of interference might happen in connection with the entire, the court, I think, knows, perhaps of not judicial notice, but it's in the record that Holyoke Center, as it used to be called, takes up that entire city block. And the whole thing, all 4 corners.
So you're saying that Classic should have known as a matter of law, once it knew that a substantial construction project of this magnitude was planned, that this degree of loss of access would occur, or this degree of interference would occur?
I'm suggesting that it does not constitute a breach of the implied covenant of good faith and fair dealing.
Well, okay, but we were trying to figure out why.
Yes, and I don't mean to be circular, Your Honor, but good faith and fair dealing. I mean, it's good faith as to what the parties expected and intended. And they expected a substantial construction project. The fact that they didn't get told that a year from now, we're going to intermittently close the road, and 2 years from now, we're going to permanently close it for what ended up being 12 months. Any more than any of the other details of the construction project, that doesn't constitute fraud. It certainly, but it doesn't constitute a breach of the implied warranty.
So they have expert evidence about access to restaurants and a welcoming environment. And so isn't there a dispute of fact about whether this degree of interference is substantial, basically? Or unreasonable based on what even knowing that there was going to be a major construction project?
I do not agree, and the reason I don't agree is because of, and I apologize if this seems like being circular, but the law regarding the implied covenant of good faith and fair dealing is clear that it is not a substitute for adding contract terms.
Right.
If there wanted to be some sort of and there was contemplation of the degree of interference by the extraordinary amount of rent concessions that were granted specifically because of the construction project going on across the street.
So how do we tell the difference? And I think you cited the Uno case.
Yes.
For the, we don't use the covenant as a substitute for terms the parties could have negotiated. Well, the parties could always have negotiated a more specific term about something that ended up being important later. But if that principle from Uno controlled the field, then we would never have a successful implied covenant claim. So how do we tell which things should have been written into the contract and therefore weren't included in the implied covenant, and which things could come out of the implied covenant, regardless of whether they could theoretically have been written into the
Understood.
contract?
And I understand the quandary, Your Honor, but there's a point where the determination is a matter of law, and the court, in looking and making that judgment, needs to look at all the circumstances and determine whether this is, for instance, if Harvard had not disclosed that they were planning on doing the top-to-bottom renovation of the Smith Center, and went into the contract without having disclosed that at all, that might be a problem.
But the details, like, well, on Thursday, the March 31st of 2017, the street's going to be closed for 2 hours. That's not something that would have to be specified.
Not just that, but, I mean, in fact, there's no line to be drawn in terms of what degree of construction work would constitute, beyond the pale. I mean, obviously,
So
beyond the pale is not a good legal standard.
It's difficult to come up with a legal standard, which is why it might be a question of fact.
It is, but it can't be where the law is that the sanctity of the contract still exists. And it's an exception to the sanctity of the contract for a party to say, yeah, but there was an implied agreement that you wouldn't do this or that you would do this so that I could reap the fruits of my contract.
Well, I don't know how it interferes with the sanctity of contract. It's implied into every contract. The parties know about it at the beginning. They know they can't do something that substantially interferes with the other party's ability to perform.
Exactly.
So in Uno, and let's just, this is something to be struggled with. In Uno, there were the court said there were multiple different ways that a particular contingency respecting a right of first refusal could have been dealt with. And so the SJC wouldn't use the implied covenant to read in a particular solution to that Uno favored, I think. So how would that, or could that apply here? I mean, were there multiple approaches that Classic could have adopted to this, or that the parties could have adopted to this issue, and is Classic asking us to read a particular promise or solution into the contract?
Well, Classic seems to be asking the court to read into the contract an agreement or a promise that Holyoke Street would stay open 100% of the time. And that was not in the agreement and shouldn't be retroactively inserted into the agreement.
I don't see them arguing that. I see them arguing about unreasonable substantial interference. I don't think they say that every moment of closure or even extended period of closure at any particular time would violate the contract. They're saying that.
Can I jump in just for a moment of clarity, because I find myself getting confused here, counsel. I'm having difficulty understanding or maybe just accepting what seems to be your argument that if it's not specifically in the lease agreement, then it's not an implied covenant, right? And so, for example, in a hypothetical, let's just say Harvard knew in 2025 that all of its students were going to be remote. Don't you think something like that for a restaurant that's basing its kind of business around the whole Harvard experience and exposure to walking to the restaurant and having families dine there, wouldn't that be a breach of the implied covenant of good faith and fair dealing if they didn't disclose that?
I don't think that particular example, Your Honor, since there is no record evidence that that was the reason. I understand the point, though.
But no, so my point is that it's implied, right? It's an implied covenant of good faith and fair dealing. And so I would imagine that you'd agree that in some circumstances, and you can disagree about this instance, but in some circumstances, there could be information that a landlord has, in this instance Harvard, that it does not disclose, that could potentially form the basis of an implied covenant of a breach of the implied covenant of good faith and fair dealing. Do you agree with that?
Yes.
And so this case was decided on summary judgment, and I'm having a hard time understanding when it gets down to kind of what I would look at as factual dispute, why the closure of Holyoke Street, and I understand that there are issues about when it was known, but at some point in time Harvard knew it, how that is ripe for summary judgment.
Because, Your Honor, it had the closure, and I know the court is well aware that it wasn't completely closed, it wasn't all the time, all of that. But whatever closures occurred to support the construction work was not, as a matter of law, was deemed not to be the kind of substantial interference that the implied warranty of good faith and fair dealing was designed to address because of what already had been disclosed and was known and could have been known by this sophisticated buyer if they had undertaken their due diligence and explored. There's no evidence that they ever asked about road closures or that they ever asked to speak to consigli or that they ever went to the building department to look at the permits. This is not the implied covenant of good faith and fair dealing, in my view, in a high altitude way, is to keep people from being unfair and deceptive to each other in a contractual situation. And the record as a whole in this case, I agree with Judge Ricciuti, as a matter of law, supports the conclusion that Harvard did not do anything that was either unfair or deceptive in terms of what it did or didn't disclose to Classic Restaurants in connection with the project going on across the street. To the contrary, the evidence is that the issue of construction was well disclosed, and if the court looks at the 72 pages of a PowerPoint presentation that was done at that Cambridge Historic Commission meeting that Mr. Goodwin attended, the magnitude of the construction was fully disclosed before they even entered into the contract. And the fact that a normal incident of a construction project of this entire city block magnitude occurred in the course of the project that had been disclosed simply, and I agree with the court below, as a matter of law, does not constitute a breach of the implied warranty of covenant of good faith and fair dealing. I see the red light blinking in my eye here. Thank you, Your Honor. If there are any other questions, or if I had any more time,
Seeing none. All right. Thank you both for your arguments,
Your Honor.
and our best wishes to Ms. Garrison.
Will do. Thank you, Your Honor.
Attorney Garrison. All right, that concludes our sitting for today. I'd like to thank our court officers, our court staff, the clerk's office, and Ms. Irizarry, our very professional scheduling person, for assistance. And with that, we'll be in recess.
All rise.